Hello everyone, welcome back to our legal consultancy series. In this video, we will talk about things to know about judicial record. There are cases in practice when you are required to provide a judicial record, such as individuals registering to establish a business. Some types of businesses require the judicial record of the legal representative of the company or capital contribution documents of shareholders establishing non-banking credit institutions. Dossiers of adopters, dossiers of application for Vietnamese citizenship, dossiers of appointment of notaries, dossiers of issuance of law practice certificates of lawyer, etc. all require a judicial record. So what is a judicial record? Today, let's find out about this topic with FDVN lawyer. Judicial record means a record of criminal convictions of a person convicted by a criminal judgment or decision of the court that has taken legal effect, the status of judgment execution, and the prohibition of an individual from holding positions, establishment and management of enterprise and cooperative, in case the enterprise or cooperative is declared bankrupt by the court. Currently, there are two types of judicial record number 1 and judicial record number 2. To learn more about judicial record classification, let's compare two types of judicial record number 1 and judicial record number 2. Judicial record number 1, granted at the request of Vietnamese citizen, foreigners who have been or are currently residing in Vietnam, state agencies, political organizations, socio-political organizations. Judicial record number 2, granted at the request of the agency conducting the proceedings, individual request. Purpose: Judicial record number 1, serving human resource management, business registration, establishment and management of enterprise and cooperative. Judicial record number 2, serving the investigation, prosecution and trial. Let the person requesting the issuance of the judicial record number 2 know the contents of his/her judicial record. Content of judicial record. Legal grounds. Article 42 of Law on Judicial Records, in the Criminal Convictions section, only states records that have not been remitted and not those that have been remitted, plus for a person whose previous criminal conviction has been remitted, and for whom information on remission of previous criminal conviction has been updated in his/her judicial records, the words "no previous criminal conviction" shall be written, plus for a person eligible for amnesty, and for whom information on amnesty has been updated in his/her judicial record. The words "no previous criminal conviction" shall be written, information on prohibition from holding positions, establishment and management of enterprises or cooperatives, shall only be recorded in the judicial record when requested by individuals, agencies or organizations. Legal ground. Article 43 of Law on Judicial Records, in the Judicial Records section, record all criminal convictions, including remitted conviction and conviction not yet remitted, plus for a convict, his/her remitted previous criminal conviction, time of remission, previous criminal conviction not yet remitted, date of judgment pronouncement, serial number of the judgment, the court which has pronounced the judgment, crime, applicable articles and clauses of law, principal and additional penalties, civil obligation in the criminal judgment, court fee, and state of judgment enforcement, plus in case a person is convicted under different judgments, information on his/her previous criminal convictions shall be written in the temporal order. Fill in all information about the ban on holding of certain posts or establishment or management of enterprises or cooperatives. Authority. Individuals may authorize others to carry out the procedures for requesting the issuance of judicial record number 1. Authorization must be in writing, in case the person requesting the issuance of a judicial record is the father, mother, wife, husband or child of the person granted the judicial record. A right. Authorization is not required. The person requesting the issuance of a judicial record number 2 must directly carry out the procedure without authorizing others. 3. Competent authority to issue the judicial record. Currently, the two competent authorities to issue judicial record are the Department of Justice and the National Center for Judicial Records under the Ministry of Justice. Judicial record granting agencies do not depend on the type of judicial record but on the subject of judicial record application, specifically, Department of Justice. Vietnamese citizens living abroad, Vietnamese citizens living in Vietnam, foreigners residing in Vietnam. National Center for Judicial Records under the Ministry of Justice, foreigners already residing in Vietnam, Vietnamese citizens whose temporary or permanent residence addresses cannot be determined. 4. Procedures for applying for a judicial record card. 4.1. Procedures for requesting the issuance of Judicial Record Certificate Number 1, pursuant to Article 45 of the 2009 Law on Judicial Records. The procedure for requesting the issuance of a Judicial Record Number 1 is as follows. The person requesting the issuance of a judicial record shall submit a declaration requesting the issuance of a judicial record and enclose the following papers: a photocopy of the identity or passport of the person issued with a judicial record card, a copy of the household registration book or certificate of permanent or temporary residence of the person who is issued with a judicial record card. Individuals shall submit a declaration requesting the issuance of a judicial record and accompanying papers at the following agencies, plus Vietnamese citizens submit to the Department of Justice where they permanently reside. If there is no permanent place of residence, it shall be submitted to the Department of Justice of the place of temporary residence. In case of residence abroad, it shall be submitted to the Department of Justice of the place of residence before leaving the country, plus foreigners residing in Vietnam shall submit to the Department of Justice where they reside. If they have left Vietnam, they shall submit them to the National Center for Judicial Record. An individual may authorize another person to carry out the procedures for requesting the issuance of a judicial record card. The authorization must be made in writing according to the provisions of law. In case the person requesting the issuance of a judicial record is the father, mother, wife, husband, or child of the person granted the judicial record card, a written authorization is not required. Agencies and organizations specified in Clause 3, Article 7 of the 2009 Law on Judicial Records, upon a request for the issuance of judicial record cards, shall send a written request to the Department of Justice where the person who is granted the judicial record permanently or temporarily resident. If the place of permanent residence or temporary residence of the person issued with a judicial record cannot be determined, it shall be sent to the National Center for Judicial Records. The written request must clearly state the address of the agency or organization, the purpose of using the judicial record, and information about the person who was issued with the judicial record according to the provisions of Clause 1. Article 42 of the Law on Judicial Records. 2009. The Minister of Justice shall prescribe the form of a declaration requesting the issuance of a judicial record card. 4.2. Procedures for requesting the issuance of Judicial Record Number 2. According to Article 46 of the 2009 Law on Judicial Records, the procedure for requesting the issuance of a Judicial Record Number 2 is as follows. Procedure: conducting agencies which request the issuance of judicial record cards shall send their written requests to provincial-level justice departments in localities where persons requested to be issued judicial record cards permanently or temporarily reside. In case it is impossible to identify places of permanent or temporary residence of persons requested to be issued judicial record cards, or these persons are foreigners residing in Vietnam, written requests shall be sent to the National Center for Judicial Records. Written requests must clearly indicate information on persons requested to be issued judicial record cards under Clause 1, Article 43 of this law. In case of emergency, competent persons of procedure conducting agencies may request the issuance of judicial record cards by telephone, fax, or otherwise, and shall send written requests within 2 working days after requesting the issuance of judicial record cards. Procedures for issuance of judicial record cards number 2 to individuals are carried out according to the same regulations as procedures for issuance of judicial record number 1. Individuals who request the issuance of a judicial record card number 2 may not authorize others to carry out procedures for such request. 5-day time limit for issuance of judicial records. The time limit for issuance of a judicial record card is 10 days after the receipt of a valid request. In case a person requested to be issued a judicial record card is a Vietnamese citizen who has resided in different localities or once resided overseas, or a foreigner has only one place of permanent residence in a province or centrally run city since he/she was full 14 years or older, and in case of necessity to verify the conditions on automatic remission of previous criminal convictions specified in Clause 3. Article 44 of this law, the time limit is 15 days. In case of emergency, the procedure conducting agency that requests the issuance of a judicial record shall send a written request to the Department of Justice where the person granted the judicial record permanently or temporarily resides. The time limit shall not exceed 24 hours from the date of receipt of the request. 6. Expiration date of judicial record. Currently, the 2009 Law on Judicial Records and documents detailing and guiding its implementation do not stipulate the expiry date of judicial record. However, depending on the nature and field of management, the term of use of the judicial record, JD, is regulated differently in other documents. For example, according to the law on bailiffs, in the application file for appointment of bailiff, reappointment of bailiff must have judicial record issued within 06 months from the date of application submission. Point B, Clause 1, Article 10 of Decree No. 08/2020/NDCP dated January 8, 2020 on organization and operation of bailiffs. In the field of adoption, the law on adoption of 2010 stipulates that the dossier of the domestic adopter also includes the JD. For dossiers of overseas Vietnamese, foreigners permanently residing abroad who adopt Vietnamese people must have judicial record issued by the competent authority of the country where the adoptee permanently resides. At the same time, the law on adoption also stipulates the validity period of papers in the application for adoption registration, in which there is judicial record. In the field of nationality, the application file for restoration of Vietnamese nationality, in addition to the necessary documents, must also have a judicial record issued by a competent Vietnamese agency for the time the applicant is applying for naturalization Vietnamese nationality residing in Vietnam, a judicial record issued by a competent Vietnamese authority for the period the applicant resides in Vietnam, or a judicial record issued by a competent foreign authority for the period the applicant resides in the foreign country. Judicial records must be issued within 90 days before the day of submission of the dossier. Above are the basic issues about the judicial record card. Hope this content is useful for you. Best regards and see you in the next video.